when doctors start disagreeing about how hurt you actually are, things get weird fast. It's like watching two chefs argue over whether a dish needs more salt, except the dish is your spine and the stakes are a lot higher. This happens more than you'd think in personal injury cases. You go to one doctor who says your injuries are serious, and then the other side sends you to their doctor who says you're basically fine and should probably run a marathon. Here's the thing, the insurance company almost always has their own doctor in their back pocket. That doctor's job title might officially be medical examiner, but their unofficial job is to find reasons why you're not as hurt as you say you are. This kind of exam is called an independent medical examination, which is one of the funniest uses of the word independent in the entire English language. You show up, spend maybe 15 minutes with a stranger, and suddenly that person's opinion carries enormous weight in your case. Your own treating doctor has actually watched you heal, or not heal, over weeks or months of appointments. That history of care is basically a paper trail that tells your real story, and a good accident injury lawyer knows exactly how to use it. The disagreement between doctors doesn't automatically sink your case, it just means someone has to explain to a judge or jury why one opinion is more credible than the other. Lawyers love this part because credibility is basically their whole sport. Things like how long a doctor spent examining you, whether they reviewed your full medical history, and whether they have a financial relationship with the defense all become fair game. A 15-minute exam versus a 6-month treatment relationship is a pretty easy story to tell. There's also something called a gap in treatment, which insurance companies love to weaponize. If you stop going to the doctor for a few weeks because life happened, because you had to work, because you didn't have a ride because you were exhausted, they'll try to argue you weren't really that hurt. Your lawyer can fight back on that by building context around why the gap happened. My client had to choose between a medical appointment and keeping the lights on lands very differently than just a blank space on a calendar. Sometimes your lawyer will bring in a third expert to break the tie, someone with no connection to either side, who can review everything and offer an opinion that feels more neutral. Think of it like calling in a guest judge on a cooking competition, who actually knows what they're eating. Juries and judges aren't doctors, which means they're really just deciding who sounds more believable. That's actually good news for you, because believability is built through consistency, documentation, and showing up, not through a single 15-minute exam. The worst thing you can do in this situation is stop documenting your symptoms because someone told you the case is complicated. Keep every appointment, write down how you feel, and tell your doctor every single thing that's bothering you, even if it feels small. Pain is sneaky, and some injuries genuinely don't show up on imaging, but are completely real and completely life-disrupting. Your lawyer's job is to make sure that reality gets communicated clearly instead of getting buried under one doctor's 3-paragraph report. Medical disagreements in injury cases aren't roadblocks. They're just a messier version of the same road. If you want to know how our team handles situations exactly like this one, check out the links in the description.